judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the State of New York, may now draw near, give their attendance, and they will be heard.
People versus Nimmons.
Ready.
May it
Mr.
please
Lucas.
the court. My name is David Wookich. I am the assigned counsel for the appellant B. Nimmons in this case. The issue before this court is whether the written submission given to the jury over defense counsel's objection, which contained both the elements of the crimes charged and, to some extent, excerpts from relevant statutes, constituted reversible error. Appellant's trial counsel objected to the written submission when it was presented to the jury. On appeal to the appellate division, that court held that the written submission did not conform with statute, that statute being CPL 310.20, but that the error was harmless. Submission in this case, which is found at page A4 of the appellant's appendix, was not authorized by statute. There are two relevant statutes in this case, two separate statutory sections. The first is CPL 310.20, the second is CPL 310.30. As the appellate division found in this case, this submission did not conform with CPL 310.20. That statute permits the court to submit to the jury a written list containing the offenses to be used as a verdict sheet.
And in fact, Mr. Wookich, there was a verdict sheet submitted, was there not?
There was a verdict sheet.
We don't have that in the papers that were put before the court, do we? Is it part of this record that's before us?
There was a true verdict sheet submitted. It's not part of my appendix. That was merely a listing of the various crimes with the possible verdicts on each crime.
And there's no question that that's a verdict sheet
question that
subject to harmless error analysis.
That's correct.
And if that verdict sheet, if the material on page A4 were added to that verdict sheet, would you have any question that that was still a verdict sheet?
Well, that very question was anticipated in the commentaries to section 310.30 of the CPL. And the answer, I think the answer to your question is it no longer becomes a verdict sheet once it contains both elements of the charged crimes and excerpts from the relevant statutes. At that point, 310.30 governs, and the two-tiered requirement of 310.30, both the consent of opposing counsel and a request by the jury is mandated. In this case, the jury did not request the instruction, further instruction on the law, and more importantly, defense counsel objected to the submission.
What was the nature of the objection?
The objection, Judge Walker, was that the submission was one-sided. The trial counsel felt that in order to be, I think, a more well-rounded presentation of the law to the jury, he mentioned reasonable doubt, that the submission should include something about reasonable doubt. He also made a reference to an identification issue. So I think that there's no question that it was properly preserved for this court's review.
Mr. Wookich, is it at least arguable whether the document submitted is a verdict sheet with the attachment that Judge Kaye just alluded to, Exhibit 3? In other words, if they were put together, is it at least arguable that that still qualifies as a verdict sheet?
I don't think it does, Judge Bellicose.
As a matter of law, it's not a verdict sheet.
I think that's correct, because if you look at the exhibit, in particular 1A, which is assault first degree, I think if you look at that excerpt, it's almost a verbatim excerpt from subdivision 1 of that statute. So I think what is relevant here is, I think with the exception of a pronoun, I think a pronoun is missing from that excerpt. But if you compare that excerpt with the statute, you'll see that it's nothing more than a an excerpt from a pertinent statute, one of the crimes charged. Therefore, CPL 310.30 becomes directly relevant. And
Because there was no objection registered on the grounds that this is in violation of 310.30.
there was no statutory reference raised by the trial counsel. The statement that was made was simply that it was not authorized, that the submission was not authorized. Grounds were given, the grounds being those that this court referred to in People v. Owens, that there was a danger of prejudice and that the submission was one-sided.
Do you argue that 31030, apart from the fact that it wasn't specifically brought to the trial judge's attention, expressly forbids as opposed to authorizing this particular document being given to the jury?
That's correct. It expressly forbids it without consent of counsel. Consent was clearly not present here. Defense counsel registered an objection to the submission. And I think that requirement has to be met.
Doesn't that make a difference in terms of bringing the matter to the trial judge's attention, that it's not a question of mere authorization, but a question of absolute prohibition under a different section?
You're saying that if the trial judge would have been, if that particular statute would have been brought to the trial court's attention, that he may have thought differently about submitting it?
Or at least he could have done something about it at that time, rather than all of us wrestling with it after all the appeals.
It may have made a difference, but I still submit to the court that there is enough on this record to preserve the issue, whether the submission standing alone is proper. And I think that this court is in a position to consider both the applicability section 310.30, 310.20. And I think there's no question that under 310.30 that this practice is prohibited. If there are no further questions.
Thank you very much, Mr. Fisher. Mr. Jolo?
May it please the court.
Why isn't this a violation under the very hard rule in Owens, which talks in terms almost per se, that you cannot give an unauthorized piece of material or writing to the jury?
Your Honor, this case is not controlled, by the rule of this court in Owens, because the purpose and effect of the document that was submitted to the jury in this case is entirely different from the purpose and effect of the document that was submitted to the court, submitted by the court in People against Owens. The concern of the court in that case was that the purpose of this document and the effect of the document was to reiterate or subordinate or substitute for the court's oral instructions to the jury. In this case, by contrast, the only purpose of this document submitted, and in fact it was the stated purpose of the trial court at the time it was submitted, was simply to help the jury to distinguish among numerous similar charges on which it was instructed.
Where do you find it authorized within the CPL?
Your Honor, it's authorized by CPL 310.20, which specifically authorizes the submission of a list containing the offenses submitted to the jury by the court.
But this goes beyond that.
Well, no, Your Honor, it doesn't. The language of the statute is submission of a written list containing the offenses.
Wasn't that contained on the verdict sheet?
Well, Your Honor, the three documents together here, Exhibits 1, 2, and 3, collectively constituted the verdict sheet in this case. Certainly, a verdict sheet could have existed with less words than existed on all of the three documents together, but that's not to say that there is one and only one verdict sheet for any particular case, and any additional words or any fewer words are going to deviate from that single proper verdict sheet. I'm sorry.
Is it your position that the court could have taken the words of the statute as to each crime and just put the words verdict sheet at the top, and that would be a verdict sheet?
Oh, no, of course not, Your Honor. What the court labels it by itself is not dispositive, although certainly the way the court explains the purpose of this document to the jury is relevant to determining what its purpose and effect is.
Well, to give the words of the statute to the jury would be error, would it not?
To give the actual text of the statute,
Right.
Yes, Your Honor.
Well, how do you distinguish the first few entries there, 1A, B, and so forth, where the crime is defined in statutory language? That's different.
Well, first of all, what's different, Your Honor, is the court was providing, in essence, the distinguishing elements of the crime. This was not presented as, it was not, in fact, the full text of any of these statutes. And in fact, to the extent that the initial purpose of reference to the elements of the crimes was to help the jury to distinguish among numerous counts, including the jury had to distinguish among 11 counts of robbery that were submitted to it. Once the court was going to give reference to the distinguishing elements of the crime, the court could reasonably
Isn't
conclude...
that really the same purpose, though, the purpose to help the jury in its understanding, which prompted the courts in Owens, Sanders, and Brooks to submit portions of the oral charge or to submit the written statute? It's always a good faith, well-meaning effort on the part of the court to give assistance to the jury.
Oh, certainly, Your Honor. In the broadest sense, any of these documents, whether the document at issue in Owens or, in fact, a verdict sheet that is squarely within the authority of 31020, is designed to assist the jury. The question is whether it's assisting the jury in a manner that is consistent with the authority of the CPL.
Of course,
or,
submitting the statute to the jury would assist them too, would it not?
yes, Your Honor, but...
That can be done only under the expressive authorization of the statute.
Exactly, Your Honor, and this is a question of degree. On the one hand, written submissions to the jury could be classified into one of three categories. On the one hand, there are written documents that fall squarely within the authority of 31020 and are unquestionably permissible. On the other hand, there are a class of documents, as in Owens, that constitute written instructions that require automatic reversal, that constitute fundamental error. And there's a third intermediate category of documents that, while they might not comport with every requirement of 31020, are in essence a verdict sheet closely akin to what would be permitted by 31020.
Well, Mr. Joe, let's try to make some symmetry of this. You cannot give the jury a statute. That's prohibited by statute.
Yes.
That's by virtue of, again, statutory prohibition. You cannot give the jury the charge or portions of the charge. That's prohibited by our case law. Now, if you look at that together, you say, well, the message there is that you cannot give the jury the law, but you can give the jury a verdict sheet. Now, if you look at this, and it captioned elements of various crimes, and you read it as it has been read, they are indications of what the law is as it defines the various crimes. Now, wouldn't that bring it either within the statutory or case law prohibition, or certainly a combination of the two?
Not at all, Your Honor. There is a tension between the statutory authority, which says that the court can submit a list containing the offenses, and on the other hand, cannot submit the actual text of the statute, and this court's decision, which says the jury cannot receive written instructions. What the court was doing here, the jury was deliberating on 15 different counts. It included 11 counts of robbery, 5 counts of robbery in the first degree, 6 counts of robbery in the second degree. The jury had to have some additional language to fulfill the purpose of 31020, which is to help the jury just see what the difference is between...
It would seem to me that might be done by reference to the counts of the indictment, not by statutory language.
Well, no, Your Honor, it's a question of being able to distinguish this in a way that's meaningful to the jury. The counts of the indictment would just say, this count is robbery first degree, this count is robbery first degree,
No, it
and
would
this count...
identify the offense, I take it, the date and place and so forth, the complained of conduct, but this is purely and simply statutory language that's on this sheet.
Well, Your Honor, it was the minimal statutory language that was necessary. In this instance, even as to the victim Ralph Pardo or as to the victim Arthur Ingram, there were 2 otherwise identical charges of robbery first degree, robbery second degree, and they were different subdivisions under the statute. The only intelligible way to tell the jury which count is which is to say, this is robbery second degree aided by another present. This is robbery second degree causes physical injury. And once the court was going to, and that's fulfilling the very purpose of 31020, which is to guide the jury by distinguishing among multiple counts that are submitted to the jury.
The Joba, the problem with that is in being selective about the elements of a statute itself being prohibited, doesn't that highlight the very danger and prejudice even more in terms of moving towards a hard right-line test, because the words that might be most prejudicial are the ones that are going to jump off the page in front of the jury, rather than a lot of the extraneous verbiage that sometimes appears in statutes?
Well, Your Honor, again, this is a matter of degree. It's unquestioned that 31020 would authorize a verdict sheet that repeatedly says robbery in the first degree, rape in the first degree, assault in the first degree, and a defendant could say, well, where's reasonable doubt and where's presumption of innocence? And yet that is clearly authorized by the statute. If the court goes a step further and says, if I'm going to make any sense of this for the jury, I have to give them the distinguishing elements so they know why robbery first degree here is different from robbery first degree here, just to tell them which is which. This was not presented as, this is the law of the case, rely on this. This is a boiled-down version of what I've already told you, but that was more complicated. It was the judge just saying, first to the lawyers, the jury's going to be hopelessly confused going through 30
Well, the
counts here.
purpose of the verdict sheet is to allow the jury to record their verdicts, is it not?
Well, it's something more than that, because it's a list containing the names of the offenses.
Yeah, but the name of the offenses against which the jury can record the verdicts reached in regard to that offense.
Well, that's one purpose, Your Honor, but it's also, if they're going to record their verdict, they have to know which count is which. And if you give them the minimal amount of language which tells them which count is which, that's certainly fulfilling the purpose of the statute. And the point is, even if this was a technical deviation from the requirements of the statute, it would still be subject to harmless error analysis. It would be unreasonable to construe Owens as a requirement that trial courts must comply. There must be strict compliance with the terms of 31020 on pain of automatic reversal, because there is this intermediate category of documents that are, in essence, in terms of their purpose and effect on the jury, verdict sheets. And even if technically erroneous verdict sheets, they are not so far beyond any statutory authority that they would rise to the level of fundamental error.
Thank you, Mr. Joba. Matter of Halyalker versus Board of Regents. Mr. Cassell, you have an identity of issues here and a full opportunity to defend. Why shouldn't we say that collateral estoppel is applicable?
Well, certainly, certainly under the case of Kaufman versus Eli Lilly, I would say that there is not an identity of issue. Kaufman says quite plainly in adopting the position of the restatement of judgments that where an issue was resolved by plea bargain or a negotiated guilty plea, it has not been actually litigated, and Kaufman does say that in that case, there is not an identity of issue.
Well, you know, these cases, and there are so many of them, can turn on very small issues and differences, but take the series of Con Ed cases. One freezer malfunctions, and as a result of that, there are billions of dollars involved and implicated in other cases involving the power shortage or outage in New York City. They were all held collaterally, subject to collateral estoppel.
But the point is that where you have a plea bargain, something which has not been fully litigated, and Kaufman really just stands it, is the latest in a series of decisions building on a substantial, consistent body of law going back, encompassing at least 7 Court of Appeals cases that I know of, from Schwartz versus Public Administrator in 1969 up through Kaufman, and incorporating Vavaliza decision, which suggests that a plea bargain is not to be given collateral estoppel effect. That was in 1974. Ramaton Home Investors in 1979. People versus Plevy in 1980. Gilbert versus Barbieri in 1981. Ryan versus AT&T in 1984, and so forth, which says that the question is not, was there a right to contest, or did the individual have counsel? That is, was there due process, and did he waive it? That's not the test, but the test is a practical realities test. Was there a full-blown litigation or only a truncated proceeding? Now, long before
You mean
Kaufman...
the test is not whether there was a full and fair opportunity to be heard in the prior proceeding?
The decision of whether there is a full and fair opportunity requires an investigation of the practical realities and not simply a due process analysis of, did he have a right which he waived? That's not the issue. The issue goes much further than that. Was there a full-blown litigation or a truncated proceeding? Even as early as Schwartz in '69, that was one of the factors to be considered. That is, the extent of the actual litigation. Was the plea induced by a lesser penalty? Or was it a compromise verdict? Was the defendant deterred by specific factors from fully contesting in the earlier proceeding? Were there further consequences? And in this case, the possibilities of future OPMC proceedings in other states, were they foreseen or foreseeable? And I have to say here, although this Dr. Halyalker had counsel, it is not at all clear, and I don't think the case turns on this, but in any event, it's not at all clear how knowing his waiver of that hearing was. There's certainly no indication that he had any hint that he would be subject to ping-pong proceedings in every state in which he was licensed. Another fact...
Excuse me, it seems to me that we're mixing up several things. First of all, you refer to Kaufman. As I recall in Kaufman, in the original case, we held that collateral estoppel would not be applicable because a certain element was not in the charge. And therefore, to hold the determination of that case binding on all other cases when those elements might be present is something quite different. But here we're talking about particular prosecutions in New Jersey where he had an opportunity to defend himself fully, and yet he pled guilty to all of them. Why shouldn't that be the same as if that issue was fully litigated?
I have to say, one has to look, and if you look at the history of the decisions here, the case law that's been developed, if you look at the context of that New Jersey situation, you had a recent immigrant to the United States who was finishing his medical training, who was told that if you accept a plea, and here's what we'll do for you, we'll give you 3 months active suspension, it will go into effect after you leave the state, you'll pay a nominal fee, you'll go on with your life. His lawyer tells him, you know, it's going to cost you more than $20,000 to defend this case. Nobody says to him he's going to face future charges. Those are the kinds of practical considerations which deter an individual from going forward. And beyond that, you don't have what's unusual here is that there's a fundamental question of fairness. We know, unlike the typical collateral estoppel case where where a defendant is arguing for a second bite, a chance to convince a second jury of something he couldn't do the first time, we know that Dr. Halyalker was not in fact guilty of the acts with which he was charged. The OPMC charged him with willful and knowing submission of 9 false forms and 2 separate fact finders, both the Pennsylvania and New York administrative panels, the only bodies which saw him in person, the only bodies which listened to his testimony, the only bodies which cross-examined him, actually had a hard look at the documents that were the original forms which were the subject of this. Both of them, those triers of fact, found that there was no knowledge or intent to submit false forms. The appellate division found likewise. So this isn't the typical collateral estoppel case. There is a substantial question of justice and equity, which is not at all theoretical and much more stark than it is in the usual case.
What is
Sorry.
your main reason for saying that collateral estoppel should not be affected here because it's a guilty plea? Is it that it has the semblance of a plea bargain?
It plainly was.
But a guilty plea or a conviction in a criminal court can be used in a later civil proceeding for collateral estoppel purposes. St. Grand maybe is cited here.
Valvalisa.
And if that's the law, many criminal cases are the result of plea bargains. How would you distinguish the situation you have here from the typical criminal plea bargain, which is later used as collateral estoppel?
Judge Hancock, Valvalisa case in 1974 says the opposite, says that a plea bargain is not a bar to subsequent civil litigation. The Kaufman case adopts the position of the restatement of judgments, which says likewise that when you have an outcome which is the result of a stipulation or a default or something other than something which evidences that the parties contested, that it should not be accorded collateral estoppel status. The Gramerton Home Investors case in 1979 says that the consequences of collateral estoppel are severe. You are depriving someone of an opportunity in court, and that if you're to do that, there ought to be at least one instance where there was a full hearing on the merits. And what's unusual about this case is that we've had two. And in both cases, the triers of fact in Pennsylvania and New York found out that he was in fact not guilty. So we have not only the theoretical issue of whether collateral estoppel should apply or shouldn't apply here, but what appears to be a demonstrably inequitable result if collateral estoppel does apply.
Mr. Cassell, do you suggest that this is a per se rule, that a plea can never be given collateral estoppel effect?
I think that the cases stand for that proposition. I think that the restatement of judgments, which the court adopted favorably in Kaufman, stands for that proposition. I do not think, however, that the decision for my client depends on that.
Do you say that this court has accepted such a rule?
I believe that that can be read out of Kaufman, out of Avaliza, and out of the other cases read together, yes. I don't think, however, that it's necessary for the determination here, because if you take what Schwartz says, the practical realities test, and look at the situation that he was facing in New Jersey in 1979, the fact that there were subsequent inconsistent adjudications in another forum, that there was really no determination at all, that it was a question of how much money he would have had to spend in his defense, that he was unquestionably induced by a lesser penalty. If you would just apply that general test rather than the specific bright line rule of no collateral estoppel effects to plea bargain, he wins on that too, under either standard. I'd like to just remind the court again of the stigma involved here. It's most important that Dr. Halyalker be allowed to clear his name. His career has been under a cloud since that guilty plea in '79. Whether or not he's actively suspended from practice of medicine, the sanction affects his hospital appointments, it affects his abilities to participate in insurance programs. In New Jersey, this guilty plea doomed his career in pulmonary medicine, and in New York, it's caused him to be dropped by GHI and undoubtedly would affect his participation in
Well,
Medicaid.
then he surely must have been aware of that at the time he entered a plea.
In '79, there's no indication of that at all. In fact, the record indicates that he was told flat out that there would be no further punishment. He was, my reading of the New Jersey transcript indicates substantial confusion of someone who was unfamiliar with the judicial process, and while he answered in English, his answers did not always reflect the questions he was asked. It's a very confusing transcript, and it reflects the fact that you had somebody who was only in the country a few years. Thank you.
Thank you very much, Mr. Cassell. Ms. Gordon, I might not agree with many of the things that Mr. Cassell said with respect to our application of the doctrine of collateral estoppel, but surely in a case such as this, where he pleads to settle up, where there is no opportunity for him to foresee the consequences as it would relate in another state, wouldn't it be rather harsh and unjust to invoke the doctrine?
My answer, Judge Wackler, is absolutely not, and I think I can expand on it for you by touching upon the two tests which I think have become somewhat confused during Mr. Glassel's argument. It is not unfair because the identity of issues test, which it was our burden to establish below, was in fact satisfied. When he was in New Jersey, he pleaded to knowingly and willfully falsely certifying that he had examined patients that he had not in fact examined. There's no doubt about that in the record, and although there may be some confusion in the briefs, the New Jersey charges, which are in the broader record, specifically find, that he pleaded to, specifically state that he knowingly and willfully committed the conduct. When he was subsequently heard in New York, his charges were the fraudulent practice of medicine and willful and knowing false reports. All of this was found established by the plea to the New Jersey charges. Now, counsel has suggested that Kaufman, and indeed other cases in this court, compel a different result because this case rests on a plea. First of all, Kaufman, and I think it's useful to look at the language just for a moment, doesn't speak to pleas at all. What it speaks to in referencing the restatements is matter that was not presented, matter that could not have been heard on its substance because of default, confession of liability, failure to place the matter before the court, and even perhaps a settlement, a stipulation that might have settled the cases that, for example, had no findings of any kind in it. As Your Honor was pointing out during Mr. Glassel's argument, what happened in Eli Lilly was that the issue that was not held collaterally estopped had effectively been waived by Eli Lilly because it had not been presented to the trial court, and their attempt to insert it later in the record on appeal to this court was simply held to waiver, so that there was no opportunity whatsoever to have the facts and thus the law determined on concerted liability. That's not the case here at all because there was a plea to specific charges. In other words, the matter, the charges, were presented to the individual. He pleaded to them, i.e. he pleaded guilty, and that plea is an admission to the underlying facts. That's basic Hornbook law. And accordingly, the problem of Eli Lilly, i.e. the matter had not been really addressed because as in a waiver, as in a default, or even as in a confession of liability. For example, in an adhesion contract where a consumer confesses to judgment and that is executed upon them without further proceedings. There is no opportunity in those cases and in the illustration cited by the restatement to address the facts. This individual had that opportunity. The fact that it was a plea bargain, I find to be not to diminish the force of the fact that he knew that exactly what he was doing. As I indicated, neither Eli Lilly nor any of the prior decisions of this court suggest that a plea bargain.
Well, he cites Gilberg
Exactly.
for that proposition. How do you distinguish
Well,
that?
Gilberg, if I recall correctly, Your Honor, was not a plea bargain. It was a conviction of a petty larceny in a city court argued to collaterally stop a different disposition of the conduct in an assault action. And this court held, based on the second prong of the test, not the identity of issue standard, but the full and fair opportunity to be heard component of the test, that he would not have had a reasonable opportunity to have defended or an incentive to litigate because here he was involved in a petty charge in a lower court, which he could reasonably expect not to have any consequences.
Yes, but it was the same factual context, it was in the same state, it was in a courtroom setting, and yet there we held no collateral estoppel. Here it's in a different state involving a different set of patients, and yet you want us to apply.
All right, well, let's take those one at a time. First of all, the fact that there's an administrative determination involved that is the predicate for collateral estoppel is no basis for discounting it, and that was so held in Ryan versus New York Telephone Company by this court. It was the same patients, not different patients, Your Honor, and true, it was in a different state. Right. True, it was in a different state. But the question is, did he have a full and fair opportunity to litigate it, and what was the nature of this bargain? In other words, why did he make the bargain? And I commend the Court's attention to the record at page 55, the appendix at pages 55, 56, wherein, in the Pennsylvania proceeding, Dr. Halyalker says why he pleaded in the New Jersey case. And he says there, I was concerned, my lawyer told me, he was counseled, Your Honors, my lawyer told me that if I went through with the proceeding, I might face greater penalties. He told me that my testimony, Halyalker wanted to testify, would harm me. And he told me that I would have to pay more money for counsel, obviously. And he also told me that I would receive no greater punishment in New Jersey, Judge Kaye, not in the rest of the world. I would receive no greater punishment than the New Jersey board was meting out to me in this particular instance. Now, by the way, it's instructive, Your Honor, what punishment he agreed to receive, namely a 3-year suspension of his New Jersey license, of which the first 3 months it was active, the balance was on probation, a fine of $2,500, and an obligation to restore the funds to the insurance company that he had inappropriately received. Now, that certainly, at least in my view, is a substantial penalty. Increments on that penalty obviously would be much more egregious to Dr. Halyalker, but by the same token, he certainly had a motivation or incentive to litigate under Schwartz because these were substantial penalties.
Are there New York cases which would stand for the proposition that because that is a plea or a plea bargain, as you've described, it should not be given collateral estoppel effect?
There is absolutely no case from this court, Your Honor, that holds that plea bargains or pleas of guilty should not be given collateral estoppel effect. Now, in my research for this argument, I came across a Second Department case that I found very instructive. Merchants Mutual Insurance Company versus Arzillo in the Second Department, 98 AD 2nd 495, decided January 1984. Now, Arzillo concerns itself with a so-called Alford or Serrano plea, in other words, a plea where the facts are not admitted, and holds, after substantial discussion, that even in a case where the facts are not admitted by the plea, that plea should be given collateral estoppel effect, citing a series of appellate division cases which hold that pleas may be given collateral estoppel effect. Now, I believe that the appellate division's analysis is sound and should be accepted, and it essentially presents a position which is a fortiori this case, because if an Alford-type plea may be used for collateral estoppel, certainly this plea, in which the disciplinee admitted to the underlying facts, had to admit to the underlying facts, is one which should be recognized for collateral estoppel purposes. Now, in terms of the fairness...
Gordon, before you go on, though, and run away with me on a fortiori, you do agree, however, as I hear you, that we're writing on a clean slate in terms of what this court has done with respect to the application of this doctrine.
I agree with that entirely, and particularly that Eli Lilly is not dispositive, and that to the phraseology, as to the phraseology in Eli Lilly, default, confession of judgment, that those indicia do not apply to this case because they look to circumstances where the issue has not been tendered to the deciding body.
And you don't think that a plea comes close enough to a confession of liability as one of the exceptional examples in Kaufman?
Not a plea where the underlying facts are admitted to by the plea. And as I just indicated, the Second Department has already held that collateral estoppel effect should be given to a plea when the underlying facts are not admitted by the plea, and that's the a fortiori. But certainly this court is writing on a clean slate in this state on this issue. I would note that to the extent that the Eli Lilly opinion refers to the restatement of judgments at paragraph 27, which I have reviewed prior to coming here several times, I find that language confusing in the restatement of judgment because the restatement says...
Our language or the restatement?
The restatement's language.
Oh, goodness.
The restatement indicates that if there were an admission at trial, that could be used as the basis of collateral estoppel. It doesn't, as I indicated before, mention the word plea, but a plea that goes to the underlying facts, not an Alford plea, is certainly, at least in my understanding, in the nature of an admission, certainly as distinguished from a default or a waiver or a confession of judgment or a confession of liability, which doesn't involve a determination or a confession to the underlying facts. So I think the restatement is distinguishable. I also think it's unclear, and indeed Merchants Mutual Insurance takes on the restatement and notes that it has been criticized in this regard in the course of the opinion.
Ms. Gordon?
Yes, Judge Kaye.
I have another somewhat different concern, and that is with the fact that there was a full hearing on the same charges in the state of Pennsylvania, and indeed there was a finding there on the facts that the physician was not guilty of willful misconduct. Why shouldn't that determination be given collateral estoppel effect, and should the commissioner be permitted to pick and choose which of various...
Which state he likes
Yes,
better.
including the state of New York, where after a factual hearing, the hearing committee made the same finding, that there was no willful misconduct.
Well, I think that's a very interesting point, Your Honor, and I would take you to page 390 of the appendix, which sets out the Pennsylvania decision, and I will call several factors to your attention. Whereas I previously said that there is, and it's not contested here other than with respect to the plea, an identity of issues between New Jersey and New York, there does not appear to have been an identity of issues between New Jersey and Pennsylvania, specifically at page 390 of the appendix, Your Honor, wherein Pennsylvania describes its charges against Dr. Halyalker as a matter of overcharging or overbilling. While certainly the fraud that he was involved in involves overbilling or subsumes overbilling, that was not the entirety of the charge pressed against him in New Jersey, nor was it the charge pressed against him in New York. So one, there seems to be a different statement of charges. As you go down the page, you will find that the hearing officer there says, since there is a technical violation, meaning a violation of Pennsylvania's reciprocity statute, which provides that you can be guilty in New Jersey of professional misconduct if you were so found in another state. That's the technical violation he's referring to. The hearing officer then goes on to say, well, given that technical violation, I don't have to decide what Pennsylvania characterized as these overcharging claims. And then he goes on to say, with respect to the balance, I find that the fact that he didn't complete some of these examinations of some of these patients, that's on page 390 to 391, the fact that he didn't complete the examinations does not amount to gross, I emphasize gross, and willful misconduct under Pennsylvania law. That might very well be. Given the diminution of the charge, it might not have amounted to gross misconduct under Pennsylvania law. And perhaps most significantly, he was not charged in Jersey or New York with not completing examinations. He was charged with never having examined individuals whom he certified that he had in fact examined. So I think that the identity of issues criterion is not made out, and I think that that permits us to dispose of the Pennsylvania matter.
What about the identity of issue problem with respect to New York and New Jersey? Are they exactly the same?
Yes, the issues are exactly the same, and one further consequence of that, raised by, I believe it was Judge Wackler before, was it fair for New York to take the second bite out of him, assuming the issues were identical? I think the answer to that must be yes. Having been in a circumstance faced with revocation of his license, settling for a 2-year suspense, 3 months active, the individual, as a matter of common sense, had to know, as Mr. Glassell has graphically pointed out, that this would be a blot on his career. I would assume that as a matter of common sense, he would also know that he was subject to disciplinary action in the 2 other states in which he held the license. But even if that were not so, both New York and Pennsylvania have reciprocity statutes, so that he knew as a matter of statute, specifically Education Law 65095B, that he could be prosecuted in New York for the same event based on essentially a collateral estoppel doctrine. And if he didn't know New York law, he had to know by operation of New Jersey law, specifically New Jersey statutes annotated 45:1-21, that he could be prosecuted in New Jersey for violations that were found of New York law. In other words, it was evident to him as a matter of common sense that the licenses that he shared among these 3 states might be placed in jeopardy by his plea, and it was open to him as a matter of law. Thank you very much, Your Honor.
Thank you very much, Ms. Gordon. Staatsburg Water Company versus Staatsburg Fire District.
Ready for please.
Marco.
May it please the court. Your Honors, I represent the appellant, the Staatsburg Fire District, and the issue in this case is whether an administrative hearing held after the commencement of a lawsuit can be used as collateral estoppel in that very lawsuit. And just very
Somewhat similar to some of the issues we discussed in the last case.
That's correct, Your Honor.
Here we have an administrative determination which was based on certain factual determinations and finding with regard to the adequacy of service. Why shouldn't that be binding?
Your Honor, what has happened here, and what we maintain is that there's a fundamental denial of due process of law because there's a manipulation here by the New York State Public Service Commission. And number one, has an order requiring and recommending that the water company pursue its remedy in court, which the water company does, and commences a legal action against the appellant defendant. The water company then moves for summary judgment within that lawsuit, and the motion is denied on the basis that there are factual issues to be determined regarding the serviceability of the fire hydrants. The water company appeals and never perfects this appeal. Never. On top of that, it is granted permission to serve an amended complaint, and it never does. Within a few weeks of that decision by Judge Garayan, the water company makes application to the Public Service Commission to increase rates. Rather than pursue its appeal, rather than prosecute the legal action, it goes to the Public Service Commission, who then schedules a public hearing. And one of the three issues to be addressed at the public hearing is the serviceability of the hydrants. The defendant, who is in court with all the rights that a defendant is entitled to in court, including pretrial discovery, trial by jury, and the right to rules of evidence being applied, which is very important in this case, is then faced with a dilemma, and I call it an unconstitutional catch-22. Does the fire district go to the hearing, which is nothing more, it's an administrative public hearing with the public present? Does it not show up and risk collateral estoppel? Does it go there with all its witnesses and have a full-blown hearing during the pendency of the lawsuit, or does it go there as was finally decided by the attorney to the Fairview Fire District? He made a record and moved and in effect requested that the hearing not be held because of the pending lawsuit, and he read a very thorough statement into the record regarding the reason that the hearing should not be held. And the administrative law judge took the statement as a motion, and he reserved decision as to whether or not the hearing should be held, and that decision was not made until well after the hearing by the administrative law judge, and he denied the motion. Now, I believe that if we're going to apply collateral estoppel to this case, then we have to address the criteria in Ryan versus New York Telephone Company, and more importantly, probably, Clemens versus Apple. If you look at both of those cases, they were plaintiffs in those cases, and they voluntarily went into the administrative hearings. And what type of hearings were they? They were confrontational type hearings. One was an unemployment insurance hearing, and that's similar to a court. The other one was an arbitration, and you may say that's similar to a court. A public hearing by the New York State Public Service Commission is in no way anything like a court. Anyone from the public could speak. We were invited to attend. It was not required that we attend. Rules of evidence were not used, and during the hearing, the main piece of evidence was a hearsay document that someone from the Public Service Commission tested the hydrants. The person that testified during the hearing had no firsthand knowledge. So being in this catch-22 position, the fire district, who was brought into the action, the legal action, we didn't have the choice, we were brought into it, said that that's where we choose to litigate these issues. And looking at all the criteria then, the nature of the forum and the importance of the claim in the prior litigation, we were in court, and that's where we wished to litigate so we could have firsthand those people that in fact tested the hydrants, because the fire district knew firsthand they did not work.
Mr. Sammarco, do you
Yes.
acknowledge that the determination of the Public Service Commission was one that necessarily decided the issue that was in dispute in the contract action?
I would make an assumption that the issues were the same, and that's why I go to the second part of the Ryan and the Clemens decisions, which has to do with whether there was an opportunity to litigate it at that hearing.
But did the Public Service Commission determine the issue of breach of contract?
Well, they did determine, yes, the unserviceability of a portion of the hydrants. They did do that. It seems unfair and a denial of due process if the Public Service Commission, and I say, in aiding a private water company, can direct the company to go to court, and when that company loses on a motion for summary judgment, then decide to hold a public hearing on the very issues that are to be decided in that lawsuit. And the fire district should have never been placed in that kind of a dilemma. We are not the plaintiff, and we did not voluntarily go into that hearing. And we did everything possible to avoid the hearing.
What did you do in the hearing?
At the hearing, I read a prepared statement. I objected to the holding of the hearing, and we requested that it not be held, and the judge reserved decision on that. Because we are a public corporation,
Is that all you did?
and I cross-examined their witnesses, and the reason I did that is there was all kinds of publicity about these cases with the Public Service Commission since about 1982. The public was there, the newspaper was there, and they had a right to know about what was occurring with respect to the hydrants.
Did you put any of your own witnesses on?
No, I did not, and in my prepared statement, I indicated I would not do that.
But you had an opportunity to do so.
We had an opportunity, but it certainly made no sense when we were in court already. And you say collateral estoppel, well, if you're in court, what is the first forum? Isn't it the court? Now, they talk about the Public Service Commission in their brief about primary jurisdiction. And if there is primary jurisdiction here, and there very well may be, they cite Flack versus Onondaga landfill. That case determined that there was not primary jurisdiction. But somebody where there's primary jurisdiction has to go to the court to stay the court proceedings to allow the administrative body to determine the technical issues. That did not happen here. When in fact happened, there was a strategy to get back to the Public Service Commission, which was a more favorable forum for the water company, as opposed to being in court to have that judge and that jury listen to the case. And
Isn't that
Yes.
really one of the unfortunate effects of collateral estoppel sometimes, that the issue, which is the important one, which may be decisive later, is going to be decided, like it or not, in some forum that you're not happy about?
But, Your Honor, that's correct. But in that instance, if the Public Service Commission had held their hearing first and then gone to court, I can understand the argument. But once you're in court, how they can withdraw the parties and try to make them go into a public hearing, and especially the defendant, who had no choice to begin with, to lose all its rights in court. There's something rotten in the state of Denmark in this case, and that's all I have to say, Your Honor.
Thank you very much, Mr. Sammarco.
Thank you very much.
Mr. Reed, isn't there a big difference between adequacy of service, that kind of a determination by the PSC, and adequacy of service to determine basically if they got what they bargained for?
No, I don't believe there is, Your Honor.
Same thing.
It is the same thing. It's the Public Service Commission is, of course, charged under the Public Service Law with supervising the adequacy of service of public utility corporations, including the respondent here. And the investigation made by the Commission was as to whether the hydrants for which the appellant was a customer, functioned adequately to provide service for the purposes of fire protection. And I believe the record shows that there were extensive tests made and conducted in a professional manner, and that the hydrants, a majority of the hydrants, most of the hydrants worked. And the commission determined, I think it was 24 out of 29 hydrants were in working order, and that the company was entitled, under its tariff, to collect revenues for those 24 hydrants. The adequacy of service is a question that has been delegated by the legislature to the Public Service Commission to make a determination, and I believe it's exactly the same thing, because that's what the appellant is paying for as a customer of the company, is for fire protection service. Now, this case involves an attempt by the fire district, which is one of the largest customers of the water company, not to pay its bills for fire protection service. And there's no dispute that the fire district is a customer of the company. The company has a tariff on file with the commission which allows it to charge an annual rental for fire hydrants. And despite the filed tariff, the fire district refused to pay the charges. When the company sought to recover overdue charges from the fire district by instituting a proceeding in Supreme Court, summary judgment was denied because in the opinion of Judge Garayan, the fire district raised a defense of inadequate service. The commission, being informed of the finding of Judge Garayan, determined that exercising its authority pursuant to the public service law should institute a proceeding, and instituted a proceeding specifically to look at the service provided by the water company.
Isn't that the same issue that was being explored in the Supreme Court action?
That same defense that was raised by the appellant in the Supreme Court
And
action.
therefore the same issue that was being explored in the Supreme Court action?
That's correct. It was the issue that had been raised by the appellant here in the Supreme Court action.
And indeed, it was the suggestion of the Public Service Commission, was it not, that the water company proceed in court against the fire company?
Yes, the Public Service Commission determined that the company should make every attempt possible, including possible legal action.
And then litigation was instituted, and it was proceeding. And then the Public Service Commission stepped in and took back that issue? Is that the chronology?
The public, I don't agree with your phraseology, took back the issue, but the Public Service Commission instituted a proceeding to determine whether the company's service was adequate.
Well, the difficulty I'm having is that seems to be the very issue that the Public Service Commission suggested to the water company be taken to litigation.
No, the Public Service Commission did not suggest that the company go litigate the adequacy of its service to the appellant in court. It suggested that we attempt to collect the charges that were due and owing the company for the fire protection service, because the commission cannot force the fire district to pay those charges.
Yes, and the fire district was taking the position that the service was inadequate.
The fire district took that position in the court proceeding, yes.
So they presumably would have made a defense.
They did raise that defense, yes.
So wasn't that the very issue that was being litigated in the court at the suggestion of the Public Service Commission?
Well, it was our impression, Your Honor, to be quite frank with you, that the commission had already made a determination that the service was adequate when we originally went to court, and that's the reason we moved to summary judgment.
Where would we find that?
There's a letter in the record from Chairman Joya. Excuse me, just a second. It's at page 10 and 11A, 10A and 11A, which tells the fire district, in essence, that it should pay its bill and avoid the problems that it's causing to the ratepayers of the water company by failure to pay the bill.
Are you suggesting they made a determination as to that issue the first time around at the PSC and then said go seek court action to enforce it, a different kind of collateral estoppel at play here? That strikes me as a very strange turnabout.
No, I'm not suggesting that at all. I was just answering Judge Kaye's question as to whether it was our impression that that letter was a determination, at least by the chairman of the commission, that the service provided by the company was adequate to the fire district.
Isn't there a potential for great mischief here, apart from, considering the policy implications that underlie the use of collateral estoppel? Because once the matter was sent back to court and that very issue was now joined, you and your client apparently went back to the PSC, because if they didn't take the jurisdiction, you perhaps sought it from them to go into a friendly forum to get that very issue now decided at the administrative level, having been sent to court in the first place. How does that serve the underlying policy purposes in terms of collateral estoppel in lessening litigation?
Well, Your Honor, I think the problem I have with that is that the Commission didn't lose jurisdiction over the water company or over the service provided by the water company simply because the water company went to court to attempt to collect its bills. Utilities go to court hundreds of times a year and attempt to collect bills. And if a ratepayer who didn't pay its bill raised issues of utility service, I don't believe that there's any support in the law or any place else that indicates that the Commission's jurisdiction over the utility service has been removed from it and placed in the hands of the judge in the court simply because the utility has gone to court in an attempt to collect its charges that are due and owing. The jurisdiction remains with the Commission over utility service, and there's no sunset or any other kind of provision in the law for when a utility company attempts to go into court and collect its bills.
Does that make the court the handmaiden of the Commission and see how things work out and see how the flow of the litigation goes and it's in control of the parties? That's the mischief part of this that concerns me.
Well, I think this is just a question of who has jurisdiction over, or at least primary jurisdiction over service issues. And this has been something that has been delegated by the legislature in the Public Service Law to the Public Service Commission. And they are the ones that have the initial say as to whether and to what extent a utility has provided adequate service. And if the Commission makes a decision that is not in that the parties do not like, they have, of course, have the opportunity to challenge it in an Article 78 proceeding. And
Assuming you're correct, did they not defer in connection with that and